Thanks, Kim. Good morning, everybody. I see a lot of familiar faces, friendly faces in the audience. That's a good thing. For those of you that I haven't met and don't know yet, as Kim said, I'm Steve Gillen. And I am a lawyer. Sounds like an Alcoholic Anonymous introduction. I've been involved in the publishing business for I hate to say it, 40 years now. And the first half of that, the first 20 years, was on the publishing side. So I started as a copy editor, became an editor, executive editor, in-house counsel, and corporate secretary for an educational publishing company that did books and software. And then the second 20 years of my career have been in private practice, representing book publishers, magazine publishers, software publishers, in some cases, and authors and artists and other creatives in other cases. And I have myself been a published book author, a published magazine article writer, and so there isn't any side of the book publishing transaction that I haven't been involved in or had the perspective, had the benefit of that perspective. And so, I think I bring to the table some range of experiences and sort of a balanced approach that you might benefit from. I am a frequent speaker at TAA conferences and have been for quite a number of years. On occasion, I talk about textbook contracts or negotiating textbook contracts, and for the last probably 15 years or so, that the topic for the textbook contract talk has always been 10 tips and 20 questions. And I was going to do that again this year, 10 tips, because I would focus on 10 significant provisions in a publishing contract rather than walk through the entire thing. And 20 questions, because there are 20 questions that you can ask that will provide you with information that you can use in the negotiation. And this year, as the event rolled around and I was preparing for it, I was talking with Kim about working on this book and maybe tying this presentation into the publication of the book if the book were published on time. And lo and behold, it was published on time. And so here we are with 20 tips, because I'm going to talk my way through the book. Now, I had an hour to speak when I was talking about 10 tips, and I still have an hour to speak, and I'm talking about 20 tips. And you can see, I think, the potential problem that we might run into. But the advantage is that now you've got a book that has all of the information in it. It has descriptive information about each provision that you're going to encounter in a typical textbook contract. It talks about what that provision is intended to accomplish. It provides sample language, specimen language from a typical contract, and then as an alternative, a little better language, and sometimes as another alternative, better language that's better still. So you have the advantage of actually seeing the language in connection with the explanation of what it means, and also some information on negotiating tips, negotiating strategies for accomplishing improvement in those provisions, as well as a glossary of terms. So if you run across a term that you don't understand, you can have the benefit of explanation. So with that said, if you've ever been published, you've seen it before. A whereas, a therefore, followed by 8 or more pre-printed pages of prose that is a little difficult to wade through because it's been drafted by guys like me. How's that? Thank you. Oh, wait a minute. What's this? Contract of indenture, it says. I wonder how that got in there. That's my TAA book publishing contract. I negotiated it myself. You know what they say about the lawyer who represents himself. Actually, this started as a little sort of private joke for myself, and as I've negotiated these book publishing contracts over the years, it would occasionally strike me that it sounded a lot like a contract of indenture. But I never went through the exercise of actually looking at a contract of indenture and comparing it to a book publishing contract. So for grins, I did that in anticipation of this talk, and I took a contract of indenture and I plugged in some of the concepts and the language of a book publishing contract, and lo and behold, there wasn't that much difference in the final analysis. So I have included this. It's only a page and a half, and I included it at the end of your materials so that you can see. It's the humor is, I think, often just a slight exaggeration of a painful truth, and I think that may be what we're learning here. The first problem that I have with all of my clients who are on the author side of the negotiation is convincing them that they've got more leverage than they think, because most of the time authors are so delighted to be presented with a book publishing contract that the only question they ask is, where do I sign? But what you need to understand is that editors are under a lot of pressure to sign new titles. If you were in Sean Wakely's presentation the other day, you saw his sales curve for a traditional print book, and you saw that if there are 100 copies in year one, there are probably only 50 copies in year two, and probably only 5 copies in year three. And what that means for publishers is that every year, as their list sales drop off of their new books, they have a hole that they have to fill just to stay even, and it's a pretty significant hole. And so there are a couple of ways that they fill that hole. One is with new editions of existing books, and another way is with new titles. And for the new titles that they evaluate, there are only a certain number that qualify, that strike them as sufficiently of sufficient quality to be considered. Of the ones that are considered, there are only a certain number that are signed. Of the ones that are signed, there are only a certain number that actually result in a delivered manuscript. Of the ones that result in a delivered manuscript, there are only a certain percentage that make it through production. Of the ones that make it through production, there are only a certain number that are successful. So you see there's attrition all along the line. In order to fill that hole, they have to fill the pipeline at the front end, and they have to overfill it, really, in order to have enough prospective content to be able to just maintain a constant revenue line, let alone increase sales, which is, of course, every business's objective. If you're, and in addition to this pressure, they have a significant amount of time and effort invested in your particular proposal. If your proposal's garnered interest, you've made the first cut. So by the time they get to that point, they have reviewed your manuscript or reviewed your proposal, reviewed other proposals as well to make the selection. They have sent it out for review, potentially read the reviews. They have made a presentation to their management, worked up a pro forma P&L statement. All of this takes time. You know how publishers move. It might take a lot of time, but keep in mind that they're under this constant pressure year after year to sign these new projects. They have all of this work to do in advance. If you get to the point where they have expressed interest in your proposal, they're already significantly invested in both, in terms of both effort as well as time, and time is the real problem. If they're getting close to the end of the year in negotiations with you and you end up not signing with them, that may be a position that they're not able to recover from in terms of replacing the time it takes to replace your proposal. So you have that leverage. Now that doesn't put you necessarily on an equal footing with the publisher, but it certainly puts you on a better footing than you might have anticipated. So as I say, the editor's already invested time in you. If you're not signed, all of this is going to be for naught, and they may be unable to recover from that. You have to do your homework.
Hey, Steve. Michael wanted to ask a question.
Yeah.
Quick question, Steve. You were talking about they need to get so many contracts by the end of the year. They have quotas. Is this like buying a car? Is it better to negotiate in November and December?
I think the answer is yes. You know, it's better. You get more leverage as you approach the end of the year. That part I agree with. Is it like buying a car? You know, maybe. But just like buying a car, you have to do your homework, okay? Information equals power in negotiations. That should come as no surprise. The editor starts with a huge advantage. That should also come as no surprise. You may do, this may be your first deal. As a consequence of your involvement with TAA, you already have a head start over a lot of your peers who don't know about TAA, don't have the advantage of the information that TAA makes accessible. The editor, conversely, has other editors, does a number of deals every year and may have been doing them for a number of years. He or she has colleagues down the hall that are doing different deals. They have advantage of the information available to them, industry information available to them. Some of the colleagues may have come from other publishers, so there's a little bit of cross-fertilization there. They get information not only from Pearson, but also information carried over from McGraw-Hill folks who have moved, Cengage folks who have moved. And so they start out with a huge advantage. You have to ask some questions to level the field, and we'll talk toward the end of the presentation about what those questions might be, why you ask them, what the significance of the answer is, and how you use that information to your benefit. You also have to determine what's important to you. Is it money? Are you in this for the royalty income that it will generate? Is it getting published on schedule and with a manuscript with a book that you're proud of that says what you want it to say? Or is it avoiding unreasonable constraints on your professional activities? If, for example, you are a professional and have an active consulting business, and the book is going to represent some of your professional bona fides. You're going to use it as a marketing tool, and that's the reason that you're involved in doing the publishing, which is not uncommon. But that publishing contract is going to have a non-compete provision in it, and you want to be sure that it's not written so broadly that will keep you from doing the sorts of things that you would otherwise do. There's no one-size-fits-all solution. Everything is negotiable. Now, I say that, right, and I have individual editors and publishing attorneys tell me this is not negotiable, right? That's not an uncommon occurrence. But oddly enough, they don't all pick the same things. And I can't tell you from one deal to the next what it is they're going to decide is not negotiable. So we take the approach that everything is negotiable until it's established that it's not. What we're going to do is look at 20 more or less typical provisions in a textbook contract. We're going to do that very quickly. Each of these provisions, as you're going through a contract proposal, should be evaluated with your specific needs and objectives in mind. There isn't any one-size-fits-all solution, as I say, and the answer that makes sense for you isn't necessarily the answer that makes sense for your colleague who might have different objectives. So, first provision that we want to talk about is the preamble. It sets the stage for what follows. It identifies the parties, the purpose, and the date. If you intend to enter the contract through an LLC or a corporation, you need to get professional assistance. And by professional assistance, I do not mean LegalZoom. It's not uncommon for individual authors, especially authors that anticipate making $100,000 a year or more off of their publishing activities, to want to set up what's called a personal services corporation or a loan-out corporation and enter the contract through that corporation. There are tax advantages and succession planning advantages and estate planning advantages to that. But if that is going to work for you, you're going to need professional help to make that happen. If that's your objective, then you don't want to enter the contract in your personal name. You want to enter it in the name of your LLC or your sub-S corporation. Most of the publishers, the identification of the publisher, if it's a major publisher, you can trust that they know who they are and that they will identify themselves appropriately in their form contract. If it's a smaller independent publisher, you might want to look to be sure that they really are an LLC, that they really have been formed and qualified to do business in the state where they're doing business, because if that's not the case, you won't be contracting with who you thought you were contracting with. You'll be contracting with some human being that you may not have done any due diligence The term grant is a term that gets used in a couple of different ways in connection with publishing contracts. It can mean a grant of rights. It can mean a grant of money. It's the same word used in two different ways. Lawyers do that to confuse you so that you have to pay us a lot of money to explain what we mean. The grant of rights can take one of a number of forms. Work for hire is one of them. It can happen with folks who are not true employees, so folks like you who are entering a contract when the subject of the contract is an educational text. Okay? Copyright law allows for that kind of work to be agreed to be a work for hire by private agreement, even if you're not in a true employer-employee relationship. Consequences of that are significant. It's explained in the book, and we don't have really time to talk. Yes. Microphone? Do we have a microphone?
We are recording the session, so if you could wait, to ask your question by the time I. No. I'm just saying, wait for the microphone.
Okay, so in the previous session next door with June Parsons about digital book report 2016, they mentioned that publishers are moving, some publishers are moving for a work for hire model versus a standard publishing contract because of what the digital industry is doing to their sales. What have you found in terms of those types of contracts and how beneficial they are to the author?
Well, they're not advantageous to the author, as you might suspect. The significant consequence of work for hire is that if your arrangement is a work for hire arrangement, then you do not have the benefit of an important provision that benefits authors in the copyright law, and it's a right of termination. So to explain that, the next best transfer, the next best type of grant that you can make is an assignment of the copyright, or sometimes an assignment of all rights in the work. That's not exactly what it sounds like. It sounds like it might be a sale, like you're selling your house, but it's actually more like a lease, like you're leasing your house, only you happen to be leasing it for 35 years. So there's a provision in U.S. copyright law that says that when you assign away rights as an author, as a human author, to your work, your copyrightable work, in 35 years after the work is first published, you have a statutory right to claw back the grant, to take it away. Okay, it doesn't cost you anything to exercise that right. It's your right under federal law, and it's a right that has a significant value, especially for works that survive into an 8th, 9th, 10th, 11th edition. It's a relatively new right, not new in that it was enacted into the copyright law in 1978, but because it was 35 years, it was dormant for 35 years. It's only been since 2013 that we've been dealing with this, really. And so there's a lot about it that we don't understand in terms of the mechanics and how it works and what the real consequences are or what the market value is, but the market value can be significant. It's a right that belongs to you. It's inalienable. You can't contract it away. It's descendable, so you can pass it on to your estate or your heirs, and you have that if you make an assignment of all rights. You do not have that if the work is work for hire. Yes. Mike. Kim? Kim's not paying attention back there.
How common is it for publishing companies to release the copyright? I did a book in 1998, McGraw-Hill, that. Got it. Okay. I did a book in 1998 with McGraw-Hill that did about 500 copies, and I was talking with some publishers' reps, and they said that if I just wrote them a letter and asked them to release the copyright, that they probably would do it, since it wasn't something that was had wide distribution. Is that common?
Well, Sean Whiteley commented on that situation yesterday, and what happens is that it would make sense that if a publisher isn't selling very many copies of a book, that they would be willing to let it go. It's not adding much value to their list, and that would be a gesture of goodwill. The contracts generally require them to do that at a certain point. But it's also the case that if your book is not selling very well, it's pretty low on the editor's list of priorities. They're not going to spend a lot of time on it. No editor ever got promoted for releasing a book. There might be some editors who didn't get promoted for releasing a book, right? So there's a bad consequence. There's a downside, not necessarily an upside. And as Sean pointed out, publishers are contemplating spinning off lists, and your book, your contract, your copyrights are part of that list. They may realize some value from it in that way, but not if they've released the rights to you.
But if you're using their company for a lot of books, it might give you some leverage to negotiate.
The more you're doing with any publisher, the more leverage you've got. Absolutely. Short of an assignment of all rights, you can have a conditional grant of rights. The conditional grant is a grant of all rights on condition that if a certain right isn't exercised within a certain set period, 2 years, 3 years, it will revert, or it can be reclaimed by the author under those circumstances. And this gets a little complicated as to how it actually gets executed in a way that doesn't prejudice the publisher's interests. But the idea being, look, we'll give you all of these rights, but if you're after a certain period of time, you're not actively out in the market exploiting them, they have no value to you. Why hold on to them? They might have value to the author. There's more common in trade publishing than in educational publishing, and less common more recently is a grant of book publishing rights. This was a phrase that was relatively common in the 60s and 70s when a book, we all knew what a book was. It had a cover on the front, a cover on the back, and pages in between, and you would hand it back and forth, or you could open it and read it. But as we've learned, a book doesn't always take that form anymore, and some of those contracts are still in force. So we're seeing litigation over whether a book is just a book the way it was understood when the contract was signed, or is a book regardless of whatever form it happens to be in, including an e-book. And the cases that I've seen so far have come out different ways, depending specifically on the contract language in the agreement, and not always in a predictable way. And so the jury's out. But I think as a practical matter, what you want to do is give the publisher what it's positioned to and committed to exploit. So the conversation is, look, Mr. Publisher or Ms. Publisher, what is it exactly that you have planned for my work? Those are the rights I'm interested in giving to you, and the rest of the rights have no value to you. Why would you want to sit on them? Now, you should be realistic about this too, because while they don't have any value in the hands of a publisher who is not prepared to exploit them, they also don't have any value in your hands if you're not going off to the Frankfurt Book Fair to sell French translation rights. If you're not in the business of, if your book is not the sort of book that's going to be the next made-for-TV movie, right? Movie rights don't have any more value to you than they have to the publisher, and so it doesn't make a lot of sense to spend a lot of negotiating power focused on this language if it really isn't going to benefit you at the end of the day. But it does make sense to raise the issue and to point out that what the language that the publisher is using is maybe perhaps not reasonable and not fair to you, because this may become something that you cede to the publisher in return for something else that does have more value to you.
My question is, I've seen these clauses that say the grant of rights is for any available, I guess, method of distribution that we know about now or in the future. What do you think of those clauses? Because it seems like the publishers are protecting themselves when they come up with some new platform.
Yeah, they all say that now.
And is there a way to is there a way to limit that?
Sure. Say take that out, and they probably won't.
Okay.
But they might. You never know. So.
Okay.
You know, publishers are nervous about what's happening in the market, about what the next media of distribution might be, and I think rightfully so. And so they're loath to cede anything to you that they don't really understand yet. And so that's the reason for the resistance. I think it's understandable. if you're not really in a position to exploit the next new thing, it doesn't have any great value to you either. Question in front?
Could we kind of hold the questions to the end? Because I really want to make sure that Steve gets through his presentation. Would that be all right? Yep. Okay, thank you.
Okay, thanks.
Royalties. In educational publishing, royalties are typically based on net receipts. That's different from trade publishing, or at least from historical trade publishing. Net receipts are the cash actually received by the publisher from the commercial exploitation of your book, less certain identified expenses. The base rate for domestic sales, the contract will generally set a base rate for domestic sales of print books, and then varying rates, typically lesser rates for other forms that the book might take and other channels of distribution. There's a wide range of these. The range is from 5 to 20%, but there are outliers. The 5 to 20% range is based on a couple of studies that are discussed in the book, one of which TAA was involved with and one of which came from an outfit called the National Writers Union. One possibility, probably not going to be volunteered by your publisher, is a sliding scale or a tiered rate structure. So we'll talk more about this in a couple of minutes, and it's discussed, I think, thoroughly in the book. But the idea is that if the publisher's offer is at a rate that's on the low end of the scale, maybe you accept that rate for unit sales up to a point that they reach their break-even point with the project. And once they pass their break-even, maybe you ask for a little bigger share of the pie. So you might start at 10% and up to 5,000 units if 5,000 is their break-even. You might ask for 12.5% once they hit 5,000. Once they hit their target margin, that is the margin that they like to have on average for their published books, then maybe you ask for even more. Maybe it's 15, maybe it's 18. If you've got a lot of leverage, maybe it's even more than that. Advances and grants. This is that grant term again in a different context. Advance is essentially a short-term loan, but it's a bird in the hand. Royalties, conversely, are two birds in the bush. So if you can get an advance, you should try for an advance. An advance ought to be accomplishable at a dollar amount that would amount to somewhere between 50 and 100% of estimated royalties on projected first-year sales would be within reason. And so, how do you figure that out? Well, that's where the 20 questions come in. A grant, conversely, is generally not recoupable, so it doesn't get recovered out of the royalties earned. There are some exceptions to that. Watch out for cross-collateralization. Most publishing contracts will have a provision in them that says if you're doing more than one book or more than one edition for us, anything that gets earned on any of those books can get used to recover our charges against any other book. And that's really, I think, not fair to the author. Each individual project ought to stand on its own two legs from an economic standpoint. Beyond that, you might find that you're getting a $10,000 advance on December 15th and having it recovered out of your royalties from the end of the year, which would be typically paid in February or March. So it might be a really short-term loan. Electronic rights, a bit of a misnomer. Electronic rights are not just electronic. They include optical rights, laser discs, and magnetic rights. And so digital rights is a term that would be more accurate, but you see electronic rights in contracts. If your contract is work for hire, or if it's an assignment of all copyrights or all rights, you've already granted these rights. It doesn't need to say that in the contract. If you have a post-1970 contract, in all likelihood, you've granted these rights because it will have provided for that. There's a question about, as I said, whether they might be included in a pre-1970 grant of book publishing rights, and the answer that we have is sometimes yes and sometimes no. Electronic rights. Prevailing rates. In educational publishing, the prevailing rate for electronic rights is the same as the domestic rate for the printed book. I keep looking at John to see, if he's shaking his head yes. So far, he is. You might hear that the prevailing rate for electronic rights is 25%. That's true in trade publishing. But in trade publishing, it's 25% of net receipts, and the typical royalty rate for the printed book is 12 to 15% of cover price, not 12 to 15% of net receipts. So that's the equivalent of approximately 25% of net receipts if it were expressed that way. And so even in trade publishing, you see that the royalty on electronic rights is roughly the equivalent of the royalty on printed book domestic sales. You'll hear some folks argue, and it's been argued in the music business, that sales of digital copies of a work are licenses, not sales. And the language in older contracts says that for third-party licenses, subsidiary rights licenses, the publisher shares those with the author 50-50. That would mean that your royalty rate on these digital product sales should be 50% rather than 15%. I think that the publishers will push back on that. Certainly the folks in the recording industry have pushed back on that. In some cases, the record labels have lost that argument. I'm not sure how it will work out for publishing contracts, but again, by now their contract language is all cut up with that issue, and it's only going to be the older contracts where you even have an opportunity to make that argument. Allocation problem. This is the real problem when it comes to electronic rights, because what's going to happen with electronic product or digital product is that it's relatively likely that those sales are not going to be your product alone. They're going to be your product in combination with something else from the publisher. So when the publisher makes that sale, all of the revenue isn't attributable just to the content you provided. Some portion of it might reasonably be allocated to other components of that product that's sold. It might be other electronic content. It might be the cost of an integrated learning system that supports that particular version of your product. What's going to happen when you see your royalty statement is that you're not going to know that that's what they've done. You're not going to know that there's been an allocation. You're not going to know what the allocation was. You're not going to know what the rationale for the particular allocation they settled on was, and you're not going to know any of that unless you hire somebody like Julie Seitz to dig a little deeper. The publishers are not volunteering that information, and you know, I think I could say that I don't trust them. Oops. Copyright. In whose name is the copyright going to be? I hear this a lot. Authors seem to place a lot of importance on this. I think it's of relatively little practical consequence at the end of the day, because what you're doing in the grant of rights is you're agreeing that it's work for hire, or you're agreeing that all of the rights are assigned to the publisher, and so to have the copyright registration certificate in your name may make you feel better, but as a practical matter, it doesn't allow you to do anything that you would otherwise do if the copyright registration were in the name of the publisher. What it might do, if you're not careful, is put your residence address on record, on public record with the Copyright Office, which might not be something that you want to have happen. Will it be registered? In whose name will it be registered? What does it mean? Well, we've talked about all of this. There's an unusual provision in the copyright regulations that allows the publisher to register the work as a claimant even if the publisher doesn't own the rights. I don't know what that's all about, but it's not as odd as it might seem for the publisher to be registering rights that belong to you. It's permitted by the Copyright Office. Competing publications. A reasonable non-compete is necessary in textbook publishing. So if you're writing accounting principles, there are certain topics that you're going to cover. You probably cover them in a particular order, and the thing that makes your book different from everybody else's book is your particular approach to that. So if you agree with Cengage, for example, to publish with them, and they publish your first book on accounting principles, and it becomes successful in the marketplace, that's a result of a combination of your effort coupled with their marketing horsepower and the other things that they bring to the table. There's really no good reason why they should allow you to take the market reputation, the following that they have built for you or helped you build, to Prentice Hall to do a competing book, so that Prentice Hall gets an advantage on. there's another good reason to have a non-compete, and that is that because accounting principles books tend to cover the same sort of material in the same sort of order in the same sort of way if both books have been written by you, should your first publisher have occasion to enforce its copyright against somebody who copies or adapts your work, one of the issues that they're going to have is proving that it was their version of your work that was copied and not somebody else's. Okay? And that complicates enforcement efforts, which doesn't serve your interests or their interests either. And so there's good reason to have a reasonable non-compete. The problem is that the provisions in most form contracts are overbroad. They're not reasonable. And so the challenge is, how can we appropriately narrow this? And all of that is addressed in the book. The one thing that you might say to a publisher is, sure, I'll accept the non-compete if you will agree not to publish another book. And what I will tell you about that is that the publisher will not agree to that. But sometimes making that point softens their position a little bit. Manuscript submission, you think you sign a publishing contract, you're going to have a book. Well, guess again, maybe not. So there's a manuscript provision, manuscript submission provision that will say, here's what you have to deliver to us, and when you deliver it to us, we decide whether it's acceptable or not. And as often as not, it will say, we decide in our sole and absolute discretion. It doesn't say sole and absolute capricious discretion, but it might as well say that. And so this is what I'm talking about. It's called satisfactory manuscript clause. Your object here should be to get them to agree to an objective rather than a subjective standard of acceptability. And so you might say, instead of acceptable in their sole discretion, you might say that acceptability would be determined by peer review. You might say that acceptability would be determined by substantial conformance to the proposal that you submitted in terms of content, coverage, length, rigor, those kinds of things, so that there is something other than their unquestioned discretion that is going to be the deciding factor that we can look to and argue about. It's also important to have an opportunity to cure. So if they say, this is this first draft is not acceptable, they should tell you why it's not acceptable and give you a reasonable period of time to fix it. Don't let the publisher have the cake and eat it too. Oftentimes these days, the consequence of a rejection of your manuscript as not being satisfactory is not that the rights necessarily get reverted to you. Sometimes the publisher says, this is not acceptable, but we're not going to give it back to you. We're going to keep it. We're going to have somebody else fix it, and we're going to charge that cost against you. So you're out of the deal, right? And the publisher continues on with your property that they are now paying a price for that was other than the price that you negotiated. Now, that seems like it's unfair. Now, if it's the second, third, or fourth edition, the publisher is going to have a significant financial commitment in your book and its success. And it may be reasonable at that point in time for them to have the right to bring somebody else in if your performance drops off. But certainly that's not, they don't have that same sort of stake, that same sort of argument at the first edition. And they should not, if they say this manuscript is not acceptable, they should return it to you. They shouldn't keep it and go on. Ancillaries and other matter, watch out for open-ended obligations. The publishing contract is going to say not only are you going to deliver the book manuscript, but you're going to deliver a manuscript for a teacher's manual, for test bank, and so on and so forth. The problem is the so on and so forth, okay? It's okay if you agree to deliver the manuscript for the test bank and the teacher's manual. The thing that you want to watch out for is that language that comes at the end of the list that says, and any other thing that the publisher might decide they want when they might decide they want it. Okay? If you don't deliver, the publisher's contract is going to say, when we talk about these contracts, we talk about a standard textbook contract, we talk about a book contract, we talk about the publisher's standard contract, but the one thing that we don't ever call it is the author's standard contract, and there's a reason for that, right? It doesn't favor you guys, it favors them. If you don't deliver something that you're contractually obliged to deliver, typically the publisher will say, we can have somebody else do it and charge the cost against your royalties. They don't say how much. And they don't say what sort of cost or what gets included in the cost. And they don't say that you get warned about the cost. They just say, we're going to do it. And it would be better and fairer if they say, look, we'll have somebody else do this, but it's going to cost you $5,000 or it's going to cost you $10,000 or whatever it is, so that you have an opportunity to say, wait a minute, give me another shot. I'd rather do that myself. Editorial control. Some publishing decisions are best left to your publisher. The choice of paper that they use. Robert Christopherson might disagree with me about some of these things, but there are decisions that the publisher is better suited to make. Substantive content isn't one of them, right? So the substance of what you're saying, the publisher is not better qualified than you are to decide whether that's appropriate. Now, there are certain editorial decisions that they may be better suited for, or that are more properly in their province, and those are things like copy editing and fixing grammar mistakes and spelling mistakes and conforming the manuscript to their particular house style. Those things are all okay. If they don't agree with the substance of what your manuscript says, then the option that's available to them, the remedy that they have, is to terminate the contract and send you packing. Warranties and indemnities, they're necessary. It's necessary for the publisher that you make certain promises about the provenance of the material that you're providing to them, because there is no due diligence that they can do that will answer the question. But they're probably drafted too broadly. They probably say that you're responsible for everything in the book, but you didn't provide everything in the book. To the extent that the title was selected by the publisher should stand behind the title. If the publisher has introduced or caused to be introduced changes or additions to the material, and if that turns out to be what the problem is, you shouldn't be responsible for that, but your contract will initially say that you are. So you should only warrant what you provide, and you should only indemnify for actual breach, not for allegations that might turn out to be frivolous. And the reps and warranties and the corresponding indemnities will say that you're responsible for any claim or allegation based on a breach. And that means that if it turns out that the allegation was frivolous, that it wasn't a result of anything that you did wrong, you're still on the hook for that. Right? And that's not fair. Consider insurance. The publisher may say, look, we'll add you as an additional named insurance to our policy. What they might not tell you is that their policy has a $200,000 or $300,000 retainer, right? Retention. And so even though you might, once you pay out of pocket $300,000, their insurance might kick in. That's not going to give you a lot of comfort. Permissions. Your publisher is better at this than you are. They do it all the time. You ought to try to convince them to do it. That there's a cost associated with that. It doesn't come for free, but they are better and oftentimes will agree to take on this task. You might ask your publisher to cover all or some of the cost. That's a negotiable point. They won't volunteer it, but they sometimes agree to that. Changes and proofs. There will be a provision that says if you make too many changes and proofs, we're going to charge the extra cost against your royalties. That's not so much about recovering money as it is about giving them a way to get you to stop making changes so that they can publish the damn book. Marketing and promotion. Reasonable for them to want to retain some flexibility here. However, publishers guard these decisions jealously, and they will ask for more discretion than they need. They will not. As reasonable as it is for them not to make specific commitments years in advance of the publication of a book about what exactly they're going to do to market it. It's equally unreasonable for them to say we're not agreeing to do anything. But they push back very hard on changes in this provision, and if you have some significant leverage, you might get some movement, but you're going to have to be creative. You may have to agree to put these provisions in a side letter, something that's not strictly speaking enforceable, but that you can use to sort of persuade them to follow through on promises that were made, or that might be useful if your editor has left and been replaced by somebody who doesn't know about the promises that were made to you. Royalty reporting and payments, typically twice a year, sometimes only once. Changes are hard to get and harder still to enforce. So it's one thing to get them to agree to approach your royalty accounting differently than they do for anybody else, but because they're accounting twice a year for thousands of works across hundreds or thousands of authors in some cases, oftentimes it doesn't happen. You have to make it happen. Watch out for cross-collateralization. As I said, charges against one book being recovered out of royalties against another. Audits. Most publishers are going to cooperate with or without an express obligation to do this. So your contract is probably not going to come with an audit provision in it. You can add an audit provision. What will happen is that in return for adding an audit provision, the publisher will say your look-back period is limited to 2 years, or limited to 1 year, or limited to 3 years. Whereas without that audit provision, you would your ability to look back would be governed by the appropriate statute of limitations, which is more likely to be 4 to 9 years. Okay? They won't tell you that you're giving up years by agreeing to this provision. That is going to be up to you to figure that out, or your lawyer. And your lawyer might not know it if your lawyer is not accustomed to doing these kinds of deals. Author's copies. Copies are cheap. Ask for many. Revisions. Each in a textbook contract, and anticipate that book is going to have to be periodically revised to keep it current in the marketplace, especially with used books and as we migrate to digital product and integrated learning systems and so on, it may be that this has less consequence. But there's a reversion clause that says if and when the publisher decides a revision is necessary, you'll look first to the author to participate on terms that are substantially the same as the terms in this agreement. That protects your right to continue with the book and keeps the publisher from cutting you out unfairly. It will also say that if you're unable because you're dead or incapacitated, or if you're unwilling to participate in a revision, the publisher can go find somebody else and charge the cost of that against your royalties. They still have to pay you to the extent that it doesn't cost them 100% of your royalties to get somebody to come in and change part of the book, and it shouldn't. And that's reasonable. They have an investment at that time, and you sort of get paid out for your interest over time, or your estate does. However, more recently, these contracts have been adding to the list of things that might cause them to give them the right to look elsewhere. Not only that you are unable, or that you didn't deliver, or that you delivered something that wasn't satisfactory, but they've added, if we think you might not be able to deliver, we can go do this. And that really, you should strike that. That's not okay. The revision clauses will typically provide for a step down. So the first edition that's done without you, the charges get cost, but not to exceed perhaps 50% of your royalties, perhaps not to exceed 25% of your royalties. There is a range of possibilities to negotiate here, and the book talks about it. You should, as inconceivable as it is at the beginning of the relationship with your publisher to think about how things are going to be wound up, that's the best time to do it. And it may be your only chance to do it. So that's when you should spend time thinking about it. Assignment. As a general rule, a contract, as a matter of contract law, a contract's assignable unless it says it's not, and yours will say it's not. Okay. Yours will say, we're looking to you for your personal performance of this. You can't assign the rights of this contract to anybody else. And you won't get any movement on that. You might ask the publisher to agree not to sign their interest in the contract. You won't get any movement on that either. Reversion. So we used to have this term called OSOP, out of stock, out of print. And historically, that was a term that had some meaning because books had a physical form. And so if a book was stocked out, that meant that there was a temporary condition and the publisher was, sold more than it expected to sell. That's a good thing. The publisher's gone back to the printer to order more quantities. If it moved from out of stock to out of print, that meant that they weren't ordering anymore and they were abandoning the book. And you could see that because there weren't any in the warehouse and there wasn't a standing order. And so under those circumstances, it was pretty clear and not really questionable that the publisher would have to revert rights to the author because it had basically abandoned its interest in that contract. But now books aren't necessarily in physical form and they're not necessarily taking up space in the warehouse. And so it's much more difficult these days with on-demand printing and electronic delivery of product to tell when a book is out of print, because as long as there is one complete electronic copy that can be used to fill a order for that book, it's technically still in print. And so the better approach these days is to use some sort of bright line test, some sort of minimum annual royalty for 2 consecutive royalty periods or 3 consecutive royalty periods. If it falls below that, you have the right to recover the rights. It doesn't mean that you have to, but it does mean that if you ask, the publisher has to comply. Choice of law venue. Choice of law is not the same as choice of venue. Choice of venue is almost always more important. You won't get either one, so don't worry about it. Signature block. Make sure the correct party signs and that you sign in the right capacity. If you've entered your contract as a personal services company, you don't want to sign it in your individual capacity. You want to sign it as the member or sole owner or CEO of your personal services corporation. You may be asked to provide your tax ID, your citizenship. If you're asked to provide the tax ID, make sure that you provide it for the right entity. It's an employer ID if it's for your LLC, and your Social Security number if you've entered in your personal capacity. You might get asked for your citizenship and your year of birth. It's not because the publisher is nosy about you. It's because they use this information either for tax reporting or for applying for copyright registration in your name. 20 questions. The first thing that you're going to want to do is learn about your editor, right? So there's a series of questions that you can ask to give you background on your editor, because it lets you know, it lets you at least guess at how much negotiating authority they might have, where they're coming from. It lets you suspect what might or might not be important to them, and it will give you information about how they feel about your particular book and any conflicts of interest that they might have. So questions like, how long have you been with the publisher? Where were you before? Did you come up through sales or editorial, because the focus is going to be different? Tell me about your current list. How many books do you sign in a typical year? Sometimes they have bonus arrangements. Oftentimes they have bonus arrangements that require them to hit a certain threshold of signings. If they say, in answer to this question, I typically sign 10, you can estimate that that's probably somewhere around their goal is somewhere around that number. How many have you signed so far this year? If they say 9, you know, I say more. How will you position my book? Who are your principal competitors? Do you have any other similar titles to mine? Get the numbers. How big's the market? What penetration do you expect? How many units will an average book sell? How many units to break even? These numbers can help you figure out where the trigger points are for escalating royalties. How many units to be a great success? How would you see my book priced? This will let you back into, given units and price and the typical discount arrangements, you can back into expected net receipts. And will it travel well? You know, is it going to be easy to sell foreign translation rights or English language rights in other countries around the world? Tell me about your foreign sub-rights and media salesability. Again, are they in a position to exploit these rights that they're claiming? You get the promotion plan. What would you envision doing to promote a book like mine? Will there be a brochure, a presentation at sales conference, journal ads? They're not going to put that in the contract. They might put it in a side letter. You might keep it in notes and find some way to use that information to your advantage. Check the back door. Roughly what % of the titles you sign actually make it into print? This lets you know whether you sign a contract or an option. Right? Is there anything else I should know about how you know about you or how you see my book fitting in? If you only remember one thing, this is the only certain thing that I know. You will not get that for which you do not ask. Right on time.
Well, we have a few minutes for questions. I do want to remind everyone that Steve wrote this book. It has a lot more information, a lot more in-depth information from what he presented today. The 20 questions are in here and explained in depth also. So I just want to make that plug. So who has a question first? Yes, please. I'm gonna.
Do not give the microphone to Robert Christopher.
Cross collateralization, sometimes called cross deduction.
Okay.
Yeah.
Yeah. Collateralization is a lawyer word, Robert.
On the matter of clawback of rights, Sorry, on the matter of clawback of rights, does that 35 years start at the signing or at the publication date?
Well, I'm trying to make this simple. It's 35. There's a 5-year window that opens 35 years from first publication of the work, or 40 years from the date the contract was signed, whichever is first.
Thank you.
Our publisher had a distributor go into bankruptcy, and he notified the authors that they would not be receiving any royalties on the sales of our books to that distributor because of this. Our contract says it is based on sales, not net receipts. Do we have any ground for arguing that we should still be paid for those uncollected receipts?
I'd have to see the whole contract, but perhaps.
My question was about not-for-profit university presses. So are those contracts more amenable to the author? Are they, because I think those books remain in print and they're not-for-profit, so.
University press contracts sort of run the gamut. So there are very tiny presses where the contracts are sometimes very onerous, sometimes very friendly. The terms are different in certain respects than a commercial textbook publisher would provide. There isn't any sort of blanket rule. There are some university presses that are very sophisticated, that have very sophisticated contracts, and their contracts are much closer to the kind of contract that you would see from a Cengage or a Pearson. So there isn't any pat answer to that question. My usual answer is it depends. It depends.
Okay. So situations like you see a lot of authors on there, not so much textbook, but turn things into e-courses, and we've got all of these online courses that have the book associated with it. If you're looking to sell the book independent of that or publish that traditionally, in terms of the granting of rights or, creating a contract that says I can still create my own course around the same content that I used to create the book.
Right.
What type of
You want to focus on the non-compete and make sure that it says, that the kind of activity that you contemplate is not going to be considered a breach of the non-compete. Non-compete. Yeah.
So this question is probably 3 years too late because I've already signed a contract. And with you being in Cincinnati, it would have been great to have read your book then because I'm also in Cincinnati.
That would have been difficult because it didn't exist then.
So maybe,
inside my head.
maybe. So you mentioned the advantages of signing your contract as an LLC if you expect to make money.
Yeah.
Is that something that if I went back to the publisher at the point that it looks like we're going to make money and said, I'd like to renegotiate so I can put it in an LLC?
Publisher would probably agree to that. There are some of the objectives that you would have had are not possible to accomplish if you're doing it after the fact. There might still be reasons for doing it.
Okay.
I have a question. In this
extra charge for questions from staff.
In the slide that was headed copyright, you said it didn't matter that much whether it's registered to your name or the publisher. Is that what you were saying?
As a practical matter, it's going to be the publisher that deals with inquiries about rights and permissions. That's the first place somebody's going to go to look to see who they contact. As a practical matter, you've given all of the rights under copyright to the publisher anyway.
I understood that. I wanted to understand how that relates to the 35-year reversion of rights. If it's
doesn't matter. If you say I'm giving you all of the rights, all of the copyrights in my work, 35 years from now, you can say, you know what, I changed my mind.
So they can register it in their name, but it still somehow is your copyright.
Absolutely.
You have the right. Okay,
yep.
Good. That's what I wanted to clarify. Thanks.
Okay. We are really out of time, but thank you very much.